the Blewett School of Law and to our symposium on Montana's extraordinary stream access law celebrating a high water mark. I'm Paul Purchase, and I'm being here, and I'm just delighted to see so many of you here and such an amazing panel. This is truly a great event to celebrate a great achievement in Montana's history in protecting our public's right to the resources of this fantastic, amazing place. This whole stream access conference, of course, reflects an incredible law or set of laws in Montana that really distinguishes our state from our neighboring states and most other states in this country in the degree of access that the public have to our rivers. And our stream access laws are extraordinary not just for the outcome, but also for the process and for the way that they show how lawyers and law can have a direct impact on the lives of the citizens of our state. And they involve every branch of government, the courts, the legislature, and the executive. And we're fortunate to have here today so many of the people who were involved in this process at every step, from the current cases through the legislative session and then the executive implementation. I want to thank the people who made this possible, and I should start by thanking Professor Marge Brown, whom I know many of you knew and who was one of the leaders of this initiative in the legislature, who founded our clinic here, our Public Lands and Resources Law Review, and did so much to make this law school the engine that it is in driving Montana's laws in the areas of natural resources and Indian law. We all owe an extraordinary debt to her. And her legacy is carried on for us by our wonderful faculty now, and Professor Michelle Bryan, whom most of you know, and who has just done an amazing job of bringing all of these people together for this conference, along with Ron Waterman. And as you all know, Ron was the architect of the legislation, and I think a symbol for us of what our politics could be and what it used to be, at least at one time, when we were able to bring people together across the political spectrum to do the right thing for the people of our state. So I want to thank them, and I want to thank our staff here. Sarah Kreider has just done heroic work in bringing this conference together. Thank you, Sarah. Thank you, Paul Wheeler and our Charles. We couldn't do these things without you. And so with that, I will turn it over to Michelle and Ron.
Thank you, Dean, and thank all of you for being here. Ron and I are so excited that this day is finally here. We actually set in my office over 2 years ago, and Ron brought all of the original papers from the stream access bill. He represented the Montana Draft Association. He was trying to retire from the practice of law, and he wanted to preserve the story. A lot of us are kind of getting up there in years. Maybe we should save this story. It's a really special story, and I agree. So we envisioned today over 2 years ago, and for the last several months we were working quite hard on it. And so part of this is to celebrate the really remarkable law, but also to remember the people and the story, and to learn from it. We are learning from our elders today, and so the program is organized as a story, and it will end with the young professors who don't know very much on that last panel, and then the governor is going to close. So he had an affair in Butte this morning, an engagement with, I think, Irish celebration of students. So he had to switch around the orders, and he's going to close things out and talk about what's the next chapter in this amazing story. A few logistical notes. Restrooms are out the doors and down the for other members of the community who want to have a copy as well. All of this is going into, including a transcript of today and a recording, it's going into a permanent archive. I want to thank the Law Library Director, Stacy Gordon, for helping us create this archive, which Ron Waterman started and others are adding to. I think Phil Harper showed up today with papers, and Jim Geddes is sharing his MSU papers with us as well. So we're really excited to keep the story alive. And I want to introduce Ron now, who planted the seed to get this all started. To my right is Ron Waterman. As I mentioned, he worked on the stream access law on behalf of the Montana Stock Growers Association. He's also in private practice for nearly 50 years, and he worked at the firm of Shell, Shanahan, Johnson, and Waterman. Did I get it right? Sorry. And he also just has been an incredible public servant, working on a lot of different interest issues for the state, including stream access and access to public defenders. We're very grateful to have Ron, and he is going to introduce our first speaker, Jim Geddes.
Good morning.
I'll get out of your way.
Good morning, and thank you again for coming. Every once in a while you have an idea, and to see that every once in a while you have an idea, and to see it come to fruition is really amazing. To feel the energy in this room, and as I understand it, there are other classrooms that are also watching this live, and it's somewheres in the internet and things along those lines that I don't know very much about. I've told many people that I don't remember all of the dinosaurs, but I was there when the last died, I think. We were comparing the law school of when I started, which was the old building that was just moved into about 3 or 4 years before I started in law school, and it was 50 years ago, and next year will be my 50th year of practicing law and actively practicing law, and it's been a great career. It is a pleasure of mine to introduce a good friend, Jim Geddes. I could go on and on about all of Jim's accomplishments, and he probably would flush in embarrassment until I got to about the first half hour or so of that, but I'm not going to do that. But I am going to say one thing about Jim. Sometimes events and people coincide, and Montana was very fortunate. In the late 1960s, Jim came back to Montana from Yale to practice law in Montana, and we had just passed a new constitution in 1972. And Jim took up that constitution, learned it, and applied it for the rights of individuals all across the state. He has been a zealot advocate in all courts, arguing several successful cases before the United States Supreme Court and many times before the Montana Supreme Court. He is an advocate who saw the path forward with respect to the individual rights of the public inherent in that document that we passed. And really, in some respects, stream access starts with the 1972 Constitution. And the language that was there became the foundation on which individuals and advocates like Jim were then able to build. And I appreciate the work that he has done, because as people look back on, I think, the history of the legal development of the law in Montana, Jim Goetz will clearly be one of those individuals who helped write seminal and important chapters. Jim.
Is this on? Okay. Thanks. Uh, Spoiler alert. Cover your ears if you want to wait until the end for the outcome. But the bottom line is we won the stream access cases. It's always nice to be introduced when you learn that the people here are going to learn from their elders. But it is true, I guess. I want to start by
Testing.
talking about my early experience with what I call navigability, which was pretty modest. But the first, if you turn to page 1 of my outline, early in the 70s, I was hired is kind of a euphemistic term. I agreed to represent the Montana Wilderness Association in combating the karst subdivision. Karst, for those who you don't know, between Bozeman and Big Sky, there's in the old karst stage, and there's now a whitewater outfit there and some cabins. But across the river, some developers planned a subdivision, and at that time they had to dedicate 1/9 of the area of the subdivision for public park purposes. So being ingenious as the developers were, most of their parkland was under the West Gallatin River. And so we raised that issue in front of Judge Gordon Bennett in Helena and argued that that land belonged to the state because of the old navigability for title doctrine. And I remember I argued it's inappropriate to have a public park underwater. And we had an interesting episode. During a break in the hearing, Judge Bennett, who was a good friend of mine, came up and said, "You know, Jim, they have a whole national park down there off Florida that's entirely underwater." So I thought, well, that argument may not go so well. But in any event, Judge Bennett, as you can see from 2 snippets on page 1 of my handout, agreed with us ultimately that the West Gallatin is navigable because there was evidence of old log floating down by Walter Cooper to a mill down by what is now Gallant Gateway. And he held that it was not appropriate to dedicate that land. They didn't meet their 1/9 requirement. So that's my early experience with navigability. Then about that time, a separate case came up. I was asked to be involved. I declined, but it was the Bighorn River and the question whether the Crow tribe or the state owns the bed of the Bighorn. And you can see, I won't get into that, it's kind of academic, but the top of page 2, the U.S. there was a doctrine called the equal footing doctrine. And we relied on it heavily in our case. What that doctrine says under the Constitution is that states which are admitted to the Union after the original 13 would come into the Union on equal footing. And the old common law said that, from England basically, said that the titles of the tidal waters and the streams that are navigable belong to the states, the original 13 states. So the doctrine was basically that the federal government held title until statehood. And when Montana was admitted as a state, then it came in on equal footing. So if the stream is navigable for tidal purposes, i.e. commercially usable, the stream is the state's property. And what happened in the Crow Indian case, tribe case, was that, I think it was the Treaty of Fort Laramie, the tribe argued that gave it title to the Bighorn River. The U.S. Supreme Court said no, the federal government held it in trust, and you can see their language at the top of page 2. Anyway, now to stream access. What happened was late 70s, early 80s, I was approached by a group of Butte sportsmen. Tom Buney is here, Tony Schuenen, the late Jerry Manley, Tom Daniels, and others. Their idea was we had a Supreme Court they thought would be favorable to stream access, and let's mount a test case while we have a good Supreme Court. Interestingly, they interviewed, to my knowledge, at least one other lawyer, Urban Roth in Butte, who was a very, very good trial lawyer at the time, certainly more accomplished than I was. I was in my early 40s. And to my great delight, the group agreed to hire me, probably because, and Urban later joked with me, he undercut my rates. But as I recall, I agreed to represent the group at $40 per hour, and they hired me, and we took off. And what I did then is prepared a very thorough memo on this equal footing doctrine, the navigability test, what evidence we have. And our basic issue was we wanted to select a defendant who was ornery enough and wealthy enough to make sure that this case would go all the way to the Montana Supreme Court. And we selected a very good candidate on that. Dennis Michael Curran, who was an oil pipeline guy who owned a huge ranch up on the Dearborn River. And then we looked at a number of rivers, and some were too obviously navigable. We also discussed the Beaverhead. And there was a landowner named Lowell Hildreth right below Clark Canyon Reservoir who was trying to keep people off and make money on a very good fishery there. So we delayed on the Beaverhead. The Beaverhead had evidence of Lewis and Clark going up the river, but very little commercial activity other than present-day commercial outfitting. The Dearborn, in our early research, seemed to have some evidence of commercial log float. So anyway, I prepared the memo. We selected Curran and Hildreth and went on our way. And at the bottom of page 2 of my handout, some I guess don't have that. Let me see if I can pull this up. Here is the old U.S. Supreme Court decision in the Daniel Ball that basically says that rivers that are publicly navigable in law are those which are navigable in fact. And then the main, if they're used as highways for commerce, and the most liberal test developed over the years was essentially commercial log floating. So there are different types of navigability under the law, as you might suspect. There's navigability for title. In other words, does the landowner or the state own the stream bed? There's navigability for the purpose of triggering federal jurisdiction. For example, the Corps of Engineers, one example I had years ago was the Libby re-regulating dam, and the Coast Guard had to weigh in on that dam, even though what the hell the Coast Guard is doing up by Libby, Montana is another question. But anyway, there's very liberal navigability for Commerce Clause jurisdiction for the EPA, the Corps of Engineers, Coast Guard, and so on. Now, the third type is more the state test, which could be ranging from recreational to commercial and so on. So we looked at all those, and what we did is I hired Al Newell of Missoula's Historic Research Associates. He found evidence of early log floating on the Dearborn. And by the way, the Dearborn is for some of you who are not familiar with the geography, got Helena down here, Great Falls up there. The Dearborn is right here. It flows into the Missouri. And then the Beaverhead is down here. And here's Lima, Dillon. And then you have the Clark Canyon Reservoir, and Hilder's Place is just below that. So we sued Curran first. And in my outline, on number 4 on page 3, I have a title called Bad News. And what happened is I called my clients, Tony may remember this. I said, there's good news and bad news. And they said, give me the bad news first. And I said, the bad news is you've been countersued for $10 million. They said, well, what's the good news? And I said, the good news is I think I could settle it for less than that. So anyway, we picked the right guy, Curran. He was going to go after us. So Curran, there was a lawyer involved from Great Falls who did not take me very seriously. And he did not do what you call written discovery on the case, which is what most lawyers would do to find out what the nature of your case. And he kept calling me and saying, well, do you have any evidence of any commercial use? And, I wasn't not honest with him. I just didn't answer the question. And so he never did until his son came on. And then he found the evidence. And I later talked to the Bozeman attorneys who represented Hildreth, and they said when he saw that evidence, he felt he was hit over the forehead with a 2x4. But in any event, I was trying to take the case to summary judgment because I was a little afraid of what a jury might do with this. And we drew Judge Gordon Bennett in Helena. The Dearborn is right on the border of Cascade County and Lewis and Clark County. And so they eventually hired this guy named Gus Karabatsis from the Corps of Engineers, or he retired from the Corps of Engineers in Omaha, as their navigability expert. Now, barge traffic on the lower Missouri is a little different from log floating in mountainous terrain in Montana. But anyway, Karabatsis came up, flew over one day, then looked at some documents, and I then took his deposition. And this is one of the cases for young lawyers out there. I've been told that if a deposition is worth taking, you should videotape it. But we didn't have a lot of money, so I didn't, and I wished I had, because I'll just read you some questions here. He first testified the issue was whether the river there's enough water in it to float logs. And he was saying, no, he flew over it. He looked at stream gauges and so on. And so I was angling for the fact that there was a canal constructed the early part of the last century that took water out, and there was irrigation. But what was the status of the river back at the time of statehood, which is the test? And so we went into the gauging station issue. And so here's the question. Have there been any other gauging stations on the Dearborn to your knowledge? He talked about one recent one around Cascade. A, not to my knowledge, this is the only one. Q, did you check with anyone? Answer, well, I checked with hydrological people of the Corps that keep track of rivers. I just asked them if there were any other records, and this was the only one. Question, so is it your conclusion that the only gauging station on the Dearborn was at Craig, the one that operated for 24 years? Answer, yes. And then I tossed a document. I had documents, handwritten, meticulous records from the teens and 20s on. I threw that on the table and I said, I'm handing you a document and ask you if you've ever seen that before. The transcript says, reviews document. No, I haven't. Well, that's kind of a benign thing. He sat there for what seemed like 10 minutes, turning pale white, trying to figure out what to say. And from that point on, he kind of ate out of my hand. The rest of the questions, that refers to a gauging station that was in operation for a period of time near Clemens, Montana. Isn't that correct? A, yes. On the Dearborn River? Answer, yes. Can you tell from that when the gauge operated? Answer, April 1921 to September 1923, May 1929 to September 1953. Question, after reviewing that, you would conclude that there at least was one other gauging station? Pretty obvious question. Answer, yes, 24 years of record. Yes, there is, right downstream from Falls Creek. So that's the lesson there is his attorney didn't prepare him very well. His attorney probably didn't know about these records. I happen to know, and he turned white. The other interesting story out of that is the deposition of Dennis Michael Kern himself. And he was arguing that people trashed his property and they had to float. His place was up on Highway 287 as it crosses the Dearborn River. And he claimed that if you floated from there to the Missouri River, it would take 2 days and people would camp out and they would trash his property. So I decided to kind of develop that, but disguise it. So I said, is it your contention that it takes 2 days to float from the bridge at Highway 287 to the Missouri? Answer, it depends on water conditions. And I was interested in ultimately interested in whether he had ever floated that. And here's the reason. Here's the Dearborn River as it comes into the Missouri. You can see down in the legend, lands owned or leased by D. Michael Curran. Now, if he's floated from Highway 287 down the Dearborn, by the way, I'd floated that, so I knew it only took a day, but I was kind of disguising where I was going. So, the obvious question for any Montanan who's ever floated is, well, does any old landowner have the right to stop you anywhere because they own a sliver of the property? So here's the questions. Is it your contention that it takes 2 days to float from the bridge at Highway 287 to the Missouri? Answer, it depends on water conditions. Question, have you ever floated that stretch of the river? Answer, yes. Then I had some diversionary questions about camping and littering and why it takes 2 days. Then back to the topic. Question, in other words, you have a section that's isolated, that the river runs through that's isolated from the rest of your property. That's right, and that's down here. So then the obvious next question is, do you know who owns the land? I mean, sometimes you have fun with these things if you're perverse about it. But do you know who owns the land along the river down here? No. Do you own the land? Do you know who owns the land down the river down here? No. And then I probably asked one too many questions. You say you floated that section from 287 down to the Missouri? Now, he's from the oil patch, so here's what he said. No, I didn't say the Missouri, just through my ranch. I've never floated the Missouri. After 2 pages before, he'd said, have you ever floated that stretch, meaning 287 Missouri. Anyway, fun and games. We went down to the Helena Courthouse on summary judgment. And one of the interesting things that was going on then was the development of the public trust doctrine. And there's a major U.S. Supreme Court case from the late 1800s, Illinois Central Railroad v. Illinois, which established the public trust over navigable rivers, that the state can't divest, even though it technically owns the stream bed, it can't divest something that's in the public trust to sell it to private interests. And fortunately, during the pendency of our case, the Mono Lake decision came down from California. Excuse me. And basically, what that case held was it applied the public trust doctrine to tributaries of Mono Lake, which had a major bird sanctuary that was threatened to be dewatered. It was an island, and if they dewatered it, it would no longer be an island. And so the Audubon Society brought the action. And the Supreme Court of California embraced the public trust doctrine, which helped us. And then Albert Stone of this law school, water law expert, filed an amicus brief, which helped us on that issue. And then, of course, we had the Montana Constitution of 1972, which said that all waters are held by the state for the benefit of the people, which is classic trust language. So anyway, I went to Helena. We argued the case. A couple interesting things I have in my outline. Miami v. Nebraska. So I was standing there at the podium arguing that this Gus Karabatsis, their expert, was a prostitute. And the late Frank Morrison was from Nebraska, and Karabatsis was from Omaha. Morrison was sort of a friend of mine. He said, well, he can't be all that bad because he's from Nebraska. And I said, and this is 3 weeks after Miami upset Nebraska in the Orange Bowl for the national championship. So I said, he'd have more credibility if he was from Miami. Some of the other members of the court got quite a kick out of that. But anyway, after I called Karabatsis a prostitute, the attorney who argued against me came up after and said, you'll be hearing from us on this. And I started to explain the law of privilege on defamation law in the courtroom, but I decided it wasn't worth my time. I can't tell you who that was, but there is a very prominent law school which bears his name. Now, finally, the Montana Supreme Court, this is a spoiler alert here, we won the case, and the Montana Supreme Court held that all surface, underground, flood, and atmospheric waters within the boundaries of the state are the property of the state, and so on. And it came out with this sweeping language, better even than I'd hoped. In approaching it, I was a little cautious about how far the court might go. And there was an old case called Heron v. Sutherland from the 30s or so in Montana, which is kind of adverse to us. So I was a little concerned, but anyway, to its credit, the Montana Supreme Court came down with the great decision. And then shortly after that, the Hildreth decision, same effect on the Beaverhead River. And at that point, of course, we were in the driver's seat, And I'm going to turn this over now to the eminent panel because I try to avoid Helena like the plague. So I was kind of a distant observer. But I do want to say one thing, and that is about Ron Waterman, because I always viewed Ron's firm, Goff Shanahan, as a resource firm. They did a lot of lobbying, I think, for mining interests and so on. And Ron represented the stock growers and the cattlemen. And to his credit, he recognized that these were sweeping decisions and the time had come to try to work together. And he led that effort. And it was a difficult effort because Jack Galt, a senator from Marr County, was adamantly opposed. A group of what I think are radical rightists from the Big Timber area strenuously fought. And Ron, you can speak to this. I don't know if you want to talk about attorney-client privilege, but I think your firm maybe lost some of those retainers as a result, even though your effort was very statesmanlike. So anyway, it's time to talk about the legislation. Thank you. Oh, very nice. Know that, by the way, I gave my files before Michelle asked for them to the MSU archives, but can be scanned. But Michelle is an eminent MSU graduate, and she should tell you about her eminent award.
The Geddes Award for outstanding. Thank you, Jim.
You're welcome.
Thank you, everybody.
All right, well, this is the second phase of this story. And I'll just simply give a little bit of a segue because Jim pointed out that the entities that I was representing were the stock growers and others. I started getting involved in this back earlier than 1983 or 1985 when Hildreth and Kern were working their way through the district court. And I think one of the things that Jim alluded to, and I think, lawyers sometimes get lucky. And we had two outstanding jurists that Jim was arguing to. One was Gordon Bennett, who's just passed last year. But Gordon was a friend of both Jim and mine. But Gordon was insightful. He was one of those individuals who understood that the law had practical effects, and he was crafting it for the future. And then Frank Haswell on the Supreme Court was also an individual who had great vision about where the law could go and how the law was meant to apply for individuals. I started working on stream access issues as Jim was litigating his way through the courts. And in the 1983 session, had proposed to my clients and then we introduced a floating bill. It was called House Bill 888, and it was basically crafted on Wyoming's floating bill, which is basically you could use the surface waters, but you couldn't touch the land. And I was successful in getting that through the first part of the first half of the session, the House, and House Bill 888 passed the House and then came over to the Senate. By then, Jim had won the two cases before the district court. There was an appeal pending before the Montana Supreme Court. And his opponents came to the Montana Stockgrowers Association and others and asked us to pull the support behind 888 because they were concerned that if 888 passed, that then they would have difficulty in winning the case before the Supreme Court. I was confronted by a lawyer who was very, very certain that Jim Goetz was not going to prevail before the Montana Supreme Court, and they wanted a clear way and a clear path. And but for that arrogance, I think we would have gotten 888 past the Senate, and we would have had an entirely different landscape before us. So after those two bills were passed, my client came back to me and asked me what we should do and how we should proceed. And my conclusion was simply this, that the law that the Supreme Court had announced was firm, and that we needed to protect the edges, if you will. What were the concerns that landowners had, and how could they live and accommodate that? Because my experience with the clients were that primarily most landowners allowed individuals to access streams. But what were they worried about? They were worried about land title and trespass, people outside of the stream and things along those lines. And although I think litigation is an excellent tool, probably to beat over the head of arrogant individuals sometimes, it's a poor way to make public policy. Public policy, I believe, needs to be made in the public forum, which is the legislature. And so if we had legislation and everybody had the same rules to apply across the board, it seemed to me as though that's what we were doing. And so that's the consequence of where we were. We went forward then trying to establish rules that everybody could play by and common sense rules that were bright line, so that landowners knew what their rights were and what they were secure in making sure that they could protect their title, and what the public's right was and what the public could do. Now we have the panel of individuals, and this is just a touch of the individuals who were involved. But what I'm going to do is ask each of these individuals to answer two very, very quick questions. And that is, number one, give us your name, the role that you had, and what was your role in the stream access law, and then what vivid memories that stand out for you as an important part of the story behind the law. And then I'll come back at the very, very end, just before the break, and I'll share what I have so that either I don't duplicate that or I can elaborate on anything like that. So, Tom, you're up.
I'm Tom Beauty from Butte, and I was one of the two people who started the stream access with Jim Geddes. But anyway, you asked about what I got out of the stream access law.
What vivid memories do you have?
Well, I have great memories, especially going through with Jim Goetz and all the things that happened, the legislature, Supreme Court. But one of the greatest things is I know that really made me happy was when Jim Goetz kept saying we're going on navigable streams. And I kept asking, well, navigable streams, what streams are you talking about? Well, we're talking about the Big Hole of Beaverhead, the Dearborn, and the Smith River. And I said, well, Jim, what about all these small streams? I've been raised in Butte, and all my life I fished the upper Big Hole for brook trout, and I love fishing for brook trout in these little creeks. I said, what about these creeks? Are we gonna challenge them? And he said, well, that's kind of a muddy issue. So anyway, as the Supreme Court ruled, they came out with a liberal ruling that all water in Montana is open for fishing, recreation, whatever. And I remember I called Jim on the phone over in Bozeman. I said, Jim, does this mean I can go fish those creeks without any landowner harassing me? He said, yes. And I said, that to me was one of the greatest things that could happen, that it opened everything for everybody. And I was just elated to know that I could still fish those creeks, and I still do this day. And I don't know, many people don't fish for brook trout, but they're fun. And anyway, that's what I remember about the stream access more than anything.
Stan.
Hi, I'm Stan Bradshaw, and I was a lawyer at Fish, Wildlife, and Parks when the stream access cases were filed, and my involvement with the stream access law actually started with the litigation. When the Department of Fish, Wildlife, and Parks was joined into both the Kern and Hildreth cases, Jim Flynn assigned me to represent the department on those cases. So I was involved in the litigation both at the district court level and Supreme Court level. After the cases were decided, and it was apparent that we were going to be looking at some sort of legislative response in the 1985 session, and the department was becoming somewhat of a clearinghouse between the various factions who were supposed to come together in this legislation. Jim assigned me to work with Ron Waterman in terms of looking at how to draft language that would actually pass muster, both protecting the integrity of the Supreme Court decision and also addressing those sort of legitimate landowner concerns. Secondarily, what I found was that I also ended up spending a substantial amount of time communicating with the leadership of the Recreation and Conservation Coalition, particularly with the leadership of the coalition, Tony Schunan, Tom Buney, and the late Jerry Manley. And then Mary Wright with Trout Unlimited. So my involvement was really sort of behind the scenes, working sort of as a grunt for Jim Flynn as part of this legislation. My most sort of compelling memory about this is not what happened during that legislative effort, but rather the way that the court framed this issue. And I think Jim Goetz did a good job of sort of describing that. And that is that they grounded their decision in constitutional and public trust terms in a way that really tied the hands of the legislature. They couldn't simply come in and do away with it. And it's my feeling anyways, that had the court simply gone with some of the traditional navigability tests in making their stream access ruling, I'm not sure that we would have any law right now. And if we did have some statute by now, it would be a pale imitation of what we've got. So for me, that was the most compelling thing about this, was the way that the court framed this decision. Without that, we wouldn't be having this conversation today.
Al, you're next.
Good morning. I'm Hal Harper. In 1985, I was the Democratic floor leader of the House. It was a tied House. It was 50-50. And the speakership went to the office of the governor. This, of course, was Schwenden. And so I got the title of Democratic floor leader. I was not able to be the majority leader. Now, Bob Marks, who was the co-sponsor, along with Bob Ream of House Bill 265, was the Republican leader. Now, he was sort of above me and maybe up alongside the speaker, but Bob signing this bill, along with Bob Ream, that balanced bipartisan sponsorship, especially from Bob Ream, was critical. Now, first, another thing. Thank you all for attending this celebration of this birthday it's a birthday for the public trust, is what it is. It's a celebration of the birthday. And it's a celebration of the public winning over the feudal system in the state of Montana. And we're very proud of this. But to follow on what was said here, the legislature does not always follow what the courts say, especially when it comes to money, but especially on issues like this. And so the judicial history was very important to the passage of this bill. But let me just list a few of the other issues that I found important. The district courts, two of them had set this up. The Supreme Court ruling had set it up. The legislature had the sense to establish an interim committee to study this. And I'm going to give House Speaker Dan Kimmis, who was the 83 speaker, credit for realizing that the other 7 bills that were crashing into each other wouldn't make it and wouldn't solve this problem. So an interim committee was appointed. Bob Ream, of course, came out of that sponsoring a bill. but along with Bob Marks, but the bill that was to pass was written by Ron Waterman. What was important about Waterman's connection with this bill was that he was known to be straightforwardly honest and very trustworthy on both sides. So that set the framework for passage of this bill. I think the best legislation comes when the two parties are almost tied or very close. And in this particular session, one party would chair one committee, but the other party would chair the next committee. They were divided evenly, 50-50. I wish current day legislators may look at this bill and the example of what happened and maybe take some lessons from it. Also, there were incredibly interested, highly motivated groups. And I want to thank every individual and every group that worked to pass this bill. Especially, there's a super delegation always from Butte Anaconda. And Tony and Lori Thomas and Steve and Al Lubeck and people like that are to be especially thanked for putting the pressure on. Anyway, it is unbelievable that this bill were to pass. Yes, the state has taken different positions from time to time on it, but right now, this is one of the great laws of the state of Montana. This state's going to continue into the future. We need to have more laws like this, people. Thank you very much.
My name is Jim Flynn. I was director of the Department of Fish, Wildlife, and Parks from 1981 to 1988. And so obviously was there in the 1985 session. When I came to the department in 1981, as Mr. Geddes had pointed out, there was already this issue of stream access percolating throughout Montana. And both landowners and recreationists would be appealing to the department to do something, and we didn't have anything to do because we didn't know what to do. And that all changed with the Supreme Court decision. So during the 1985 session, the department's primary interest was getting a bill so that we would have legal authority and guidance from the legislature, and primarily the authority to go into the rulemaking process to administer the law and address this percolation that was going on throughout the state of Montana. The thing I remember most about this legislation is that, as has been mentioned, and I'm sure will be mentioned more, there were a lot of stakeholders or interested parties, whatever term you want to put to groups around the state of Montana, sportsmen's groups, the Coalition Access, the Stock Growers Farm Bureau. And during the 85 session, they were all focused on this bill that Hal described in some detail. And as it went through the House, what came out of the House was a pretty darn good piece of legislation that I, as a department director, was reasonably comfortable with. It would fit the needs that we had to administer a law into the future. And the bill went to the Senate and went to a Senate subcommittee, which held a late night meeting. And I don't remember all of the members of that committee, but I know Senator Tao was a member of it. And they pretty well emasculated the bill. The term we used in the legislature was gutted the bill. And the thing that struck me most was when that meeting was over, Jerry Manley from the Coalition, being from Anaconda, I can use this term, a real Butte rat, and two ladies, I can't remember their names, who were representing Montana Farm Bureau, came up to me just livid And the first question they asked was, can they do this? And I thought, well, folks, welcome to the real world of the Montana legislature. I didn't tell them that. But I said, yes, they can do that. And well, what do we do now? What do we do now? They ruined our bill. So I said, well, we've got to go back to what we had coming out of the House and work hard and get it done. On the way home that evening, I got reflecting back on that, and I thought, you know, this is the first time I have heard the words we and our in this process. And so you had this fellow from Butte and these two ladies from the Fairfield Choteau area. I can't remember which community they were from. One representing farm landowners, one representing the access group, using the words we and our bill. And I thought, okay, we got a road to hoe here, but we're going to make it, because now people have got ownership in this thing, and we're going to go good from here.
Well, good morning, and thanks again for this panel and everything, and for inviting me. I had some misgivings about coming, but I'm here, and so I'll tell you what my initial role was in this thing. And that
What's your name, Bruce?
Oh, Bruce Crippen from Billings, Montana. And I was in the state senate at the time. My initial role was to drive a stake through the heart of this bill and put it out of its misery. Now let me explain why. I was we were in the minority in the Senate, and I was the Republican whip. The Republican whip has a role where it helps all the members of the Republican caucus. And I was approached by leadership, and would I be willing to help Senator Jack Galt, who was a member of the Judiciary Committee, as I was. He had a bill that was coming in there that dealt with stream access. Well, now I was a tax guy, I wasn't a water guy, and I said, no, you know, this is not my bailiwick. And besides, don't have a dog in this fight. But they said, well, Jack is going to be in there. He's going to be up against Tom Tao. And you don't want to be up against Tom Tao. And Bill Yellowtail. And he needs some help. And I said, well, all right, let me look at the bill. And I'll do that. Well, I took one look at the bill, great on purpose, but a typical House bill wasn't worth a damn as far as construction. And it needed a lot of work. And I thought, well, okay, there's some things that we could do here on it. And then during the initial stages of this thing, I realized that all the ag folks that I thought would be against this bill were in favor of it. You know, the only body that wasn't in favor of it, wasn't even on it, was the Vatican. They had everybody else on the bill as co-sponsors. But then I thought, well, if this is such a great bill and the Democrats are really in control, why is it in a subcommittee? They could just blow this thing out, be done with it, and go on down the road. And so with these things in mind, I said, okay, I would be willing to help Jack, but somewhat, albeit reluctantly, because I didn't have any ag people in my Senate district. I had sports people in my district. In fact, some of them throughout this process called me up and said that they're going to vote against me and run against me in the next session. And so with that, and so we did. And so the first, it went to a subcommittee, of which Tom Tao, Bill Yellowtail, brother, and Jack Galt and I were the other two. They're just two of us. So I thought, this is going to be, we'll have a good time. We'll get something done here. And walked in the first night, and in the old Supreme Court chambers, and in the gallery, it was loaded with people. I mean, people. And they were angry. And they weren't angry at Tom Tao, and they weren't angry at the people that were supporting them. They were angry at me. And I think if anything was going to be, stake was going to be driven in anybody's heart, it was going to be mine. And I thought, this is going to be interesting. So what we did, I was just placed in a position as an attorney where I agreed to help Jack Galt. Now, Jack and I always didn't get along. He's sort of a crusty old, I was going to say bastard, but he's out to say old fella. And you know, and I fought him a lot of times along the way. But I agreed to do it. Once you agree to do that thing, then you go in And you looked at the bill, and I could see there was a lot of areas that we could work on and maybe make it a better bill and go through it. So that's what we went it into. And we started in, and I don't remember any of the issues. I know that my co-sponsor over here, my co-friend here, Tom Tao, well, he has, look at all that. He's got the minutes. This is what I got. And my memory, I can't remember what I did this morning, much less 33 years ago. But nonetheless, he will give a lot of the information on some of the issues that we had. But what we did, once we were in there, and you realized that this bill was going to pass, and it had a very good purpose, then we were able to start to work together. And that's what a subcommittee is in the legislature is designed to do, is to take a bill like this, work together, as we could do. I don't know if they do that now, but we could do it then. And I knew Tom Tao would amend everything, and he likes to amend. And he normally does a pretty good job if you watch him closely. And we could come up with some piece of legislation, fix what the House sent over, and go down the road. And we did. And then we had our battles. And one more minute. I think I've got a minute and a half on mine. Okay. But one of the memories that I have was, of course, Bill Yellowtail. Now, Bill Yellowtail was a young kid who was his freshman year. He was down by Wyola. And I think he thought Republicans were the incarnate of the devil because he didn't look upon Jack Galt and I with favor. And he was the chairman of this subcommittee. And we would get into some of these debates and growing real great, Tom and I, and he'd fold his arms like this. And that would be the end of the debate. And Bob Brown was my roommate. He was in the state senate, but he wasn't a member of the committee, but he was in the overall committee. I got a hold of Bob and I said, we got to do something with this young fella. I mean, geez, we're not getting anywhere. We're not going to have any fun anyway. And so I said, let's take him out, get him a few pops afterwards, and buy him a burger and some beer and talk to him. We ended up to the point when he would stop, he wouldn't hold his hands. He turned out to be a good guy. It was always a pleasure working with my friend over here. We had some great battles during this legislative session. I think we ended up with a pretty good piece of legislation. And even though I was forced to vote against it, because of Jack.
My name is Tom Tao. And when I first got the invitation to be here today, I went down to my library to see what I had on stream access, and I was kind of surprised. Got a whole book. That was what I took out of the legislative session, and it has a lot of material. I was on the Judiciary Committee in 1985. I was also appointed to the subcommittee, as Bruce has indicated, and as far as I can determine, there were only 4 of us on the committee. And it had quite an impact, I suspect. The problem was most of the votes were 2-2.
Amazing.
Bruce was on one side and I was on the other side. And so the chairman, well, I don't know whose idea it was, but at any rate, we came back to the major committee and said that these are the issues that we deadlocked on. So we went through, I think it was 7 or 8 issues that were deadlock issues. And Bruce would make the motion on his, and I would make the motion on mine, and we went through the bill that way, and then concluded by passing the bill. I think it was 7-3 in the final vote. In any event, some memories. The first thing I remember is that when I first opened the bill and looked at it, and it said Bob Ream and Bob Marks, this chief sponsor. Wow, what's that? I mean, these are 2 people that I would never believe would ever be together on anything. So that's quite an impression. Second impression was, and I opened this to the minutes on this, when Ron Waterman came up to produce the bill and to explain the bill, he said he was appearing on behalf of the Montana Stock Growers Association, Montana Wool Growers Association, Montana Association of State Grazing Districts, Montana Cowbells, Montana Farmers Union, Montana Cattle Feeders Association, Montana Farm Bureau Federation, Montana Water Development Association, 15 different organizations. I was really impressed. And they were all in the same bill. That surprised me. Third thing that surprised me is there were 40 opponents that day. I've got them all listed here. I got notes on what they said and everything else. That impressed me as well. So it was quite a bill. I was quite impressed with it. Joe Mazurik, the chairman of the committee, appointed a subcommittee. We had, I believe it was at least 4 or 5 meetings. I have them listed here. And as a result, we took up a number of issues, and some of the issues I just jotted down this morning, some of them that we struggled with. One of the big questions was, do we want to include lakes? This is a stream access bill. Should we include lakes? Well, I thought, why not? And then we were told, well, they kind of had that in mind. And Bruce didn't like that idea too well.
Bob Brown.
Bob Brown didn't like it. He was really adamant about it. In any event, lakes were in, then they were out, then they came back in again. And I'm not really sure. The bill, I think, passed the Senate committee with lakes out of it, but that was in and out. In fact, as I recall, the subcommittee came up, and this was an interesting aspect, which is kind of unusual. I guess I should say extremely unusual. At the time that the subcommittee met and we went through all of these things, I think Ron came to me and said, hey, we don't like this. And here's what we think you ought to do. And he wrote a whole bunch of amendments, and I took them into the committee, and I said, fine, I think that Ron has a good point, and I think we ought to pass these amendments, which he went through and made it, I thought, a really good bill. But then Bruce came in with another set of amendments from somebody else, I don't remember who, the opponents anyway, and it was exact opposite. And the committee, after quite a bit of discussion, set a spy on both of your houses and threw it out. Neither one of us got that. And Goetz started going through the deadlock issues one by one. And some of those issues, by the way, portage around natural barriers, activities within 300 feet or 500 feet of residence or dwellings, navigable versus class 1, class 2 waters, and is the permission of the landowner needed, especially in class 2 waters, which is really the non-navigable waters. And compensation, if they have to go around on portage, should there be compensation? And if there should be compensation, does that mean there's a power of eminent domain so that they can be, in fact, enforced that way? And could there be hunting without permission? And that was a big issue. We argued that for a long time, and I think we finally kind of concluded that, well, we'll allow bow and arrows and something else, black powder, yeah, black powder and only. And then what about permanent structures? Do we want? Okay, I'm at the end, so thank you.
Yeah, my name is Tony Schoen from Butte, and I reiterate a lot of what Tom said. I've been a fisherman my whole life. I had a guiding service for almost 50 years. So stream access was very important to me, but I just wanted to mention a few things during the legislation. Tom had purchased a sporting goods store, so it was left up to Jerry Manley and I to go to all these sessions at the legislature. And I remember one thing with Jerry, he was very loud, if you want to emphasize loud, and cuss quite a bit. And I was up on the 3rd floor of the Senate, in the Capitol there, trying to lobby a senator, and Jerry was down in the rotunda. of the Capitol. And the senator walked, you could hear Jerry all the way up there. And he walked over to the edge of the balcony and looked down. Can't they find a cage for that guy? But the other thing that really comes to mind when Tom and Bruce were talking about people being mad, in those days, the Medicine River Canoe Club, which was led by the late Jim McDermott, we were allowed to bring when the bill was being heard in the Senate, all these people with paddles and oars and everything else were up in the top of the balcony, pounding on the balcony floor. Well, they got the attention of the legislatures, I'll guarantee you that. I remember Jack Galt and Bruce standing down below when they looked up to see what the hell was going on, you know? But, and then other thing I really want to appreciate all the people that helped out, Ron Waterman and our attorney, but he's a hell of a lot better attorney than he is fisherman. They take fishing all the time. But anyway, at that time, too, there was a Representative Kurt Kruger. He's a district judge in Butte now. And you don't do that anymore either. He formed a committee, and we were on he put Jerry Manley on this interim committee to, you know, hash out. You always have to make compromises on something this difficult, you know. And so I recognize the fact that we could all get together and talk about it. And when some of the guys mentioned the people, now I want to say from Sweetgrass County, they came in by the busloads. And I just thought they were going to torpedo the bill. In fact, one guy, and I don't want to mention the name in respect for his family, he came in his Confederate uniform. I mean, that's how serious some of these people were in those days. But we were just as serious in our effort, too. And so, I mean, I really wanted to thank all these people that Bruce wasn't for us, but in fact, every time I saw him down there, he's talking to Jack Galt, who was our arch enemy on this whole deal, you know. But anyway, I'm really happy that the bill passed. And the one thing, when I said I was a guide and outfitter for almost 50 years, two of the clients that I wished I could have disposed of while I was taking them down the river was David and Charles Cope. And, but I didn't do it. It would have been so simple. I had just a little teeny boat that nobody would have questioned the damn thing if it had turned over. You know? So thanks a lot.
That is a hard act to follow. But here I go, trying. My name is Mary Wright. My involvement in the '85 session was as a lobbyist for Trout Unlimited of Montana. I moved to Montana because of its rivers. I'd been a lot of places in the world I wanted to go back to, but after I vacationed in Montana on the Smith River, I had to come and figure out a way to make a living. So I was an outfitter at the time, had an active business. I was also an attorney, and I had experience in drafting and lobbying pretty complicated pieces of legislation and regulations as well. So I thought I had something to add to the process. I had a couple of problems. One was, since I'd only been in Montana for a few years, you know, there is an attitude you hear every once in a while that you're an outsider unless you were your grandfather and everybody else was born here. But fortunately, I never got that reaction, at least not straight to my face. My other problem was I didn't know anybody in Helena. I didn't know my own legislator, but that changed very, very quickly. The memory that is significant to me is the extraordinary communication and cooperation among the various groups that formed the proponents of the stream access bill. I'd never had an experience quite like that, and I'm sure glad I did. Thank you.
Good morning. My name is Stuart Doggett. And, actually, I grew up in White Sulphur Springs on a cattle ranch, which is still in operation today. In the 85 session, I was a 24-year-old junior lobbyist. It was my very first session. And my role was to monitor legislation, talk to legislators that I was assigned to, and to learn. And boy, did I. I drank from a lot of fire hoses that session, and this bill certainly opened my eyes. But nonetheless, I continue to lobby to this day, and I enjoy the process. And I reflect back on this bill and the collaborative effort that we enjoyed and worked on. But you know, it was interesting. I wasn't too far away from the ranch, but a lot of the people where I grew up in Mark County were opposed to the bill, but the association that gave me my first job was for the bill. And my reflection is to recall those meetings behind closed doors. We had a boardroom at the Montana Stock Growers building, and I still love that room to this day, but we had a lot of long, deliberate discussions. I remember Ron well. I admired him then, and I still do, for his role in those discussions, because we had a lot of our members that wanted us to change positions, a lot of members that were very emotional and upset about the Supreme Court rulings, and a lot of members that took their emotion to extremes about all the potential hazards and criminal activity. And you can't believe the stories that we heard that was going to happen with this bill. But the good thing is we had great leadership in Ron, who basically was able to break down for a group of ranchers and non-lawyer types the reasons for taking legislative action and the reasons that taking legislative action would preempt further litigation and help resolve this issue. And you know, it was very well reasoned in that area. And again, as I'm a 24-year-old kid, I'm listening and learning a lot by it, and I was very convinced by it. The other person who was very instrumental was my boss, Mons Tegan. He was the executive director of the Montana Stock Growers Association, a rock-ribbed conservative from the Lewistown area who came and worked for Governor Babcock and then went into the association management business. And he was a great mentor for me. But he also had worked on a lot of legislative efforts, and he too, after the Supreme Court ruling, was very good in helping guiding the association to be in support of the legislation and the merits of that. You know, we lost membership in the Montana Stock Growers Association because of the bill. Not a great deal, but we certainly took a lot of heat, and I admired those folks behind the closed doors that kept it together. The third person who was very key in that was Jimmy Wilson. Jimmy was the president of the Montana Stock Growers at the time from Trout Creek. He actually went to school with my dad, but Jimmy was a very well-spoken rancher, very open-minded, conservative, but he started most discussions by listening. And he did a lot of listening, and he let people vent, and I learned from it then. It's like I wanted to immediately respond to people, but he would take it, listen, and he would process it, and then he would respond. But he helped keep the organization focused and on the merits of supporting the bill. And I just recall a lot of those discussions in those boardrooms, and the heated discussions we had. But when we came out and opened the door and we went to the legislature, we had what Tom Town referred to. We had unison, and we had people standing behind that bill with agriculture coalitions, and the major ag groups in this state were standing behind the bill, working with one another. And I think that says a lot for the stock growers, that they stepped forward to do it. Yes, they had the Supreme Court ruling there, but it also says a lot for the recreationalists, if you think back to it too, because many of them could have taken the generous ruling that they'd received and just ran with it and continued probably to have a real open-ended access. But they worked with us to define it, and I think it was to their interest and everyone's interest, because there was a lot of concern out in the hinterlands about what the law meant. By framing it and passing it a bill and giving it definitions, I think it was good for both sides of the occasion, and I certainly learned a lot from working on it.
Thank you. My name's Tony Shonen, and I live here in Missoula, formerly from Butte. And like Stu, I was just a young guy. I was in my early 20s, and I haven't seen Stu for 33 years, but I knew you guys were having those behind closed door meetings. So I worked for the Montana Wildlife Federation as an intern lobbyist. I was a student here at the University of Montana. My job was primarily to work with the 18 affiliate rod and gun clubs that we had across the state of Montana. At that time, all of these rod and gun clubs were very supportive of House Bill 265. I would get information from those folks. I would garner opinions. I would pass that information along to my two fellow lobbyists, Hal Price and Dan Hines. I would say my phone traffic was probably 50% from Butte and Anaconda. And of that 50% of that 50% was probably from Jerry Manley. I think probably one of the most colorful happenings that were associated with the passage of House Bill 265, and it was alluded to by Senator Tao and my father, and Senator Crippen and Director Flynn, was when the House passed the bill to the Senate. And there was a contingency of senators that felt very strongly they didn't like that bill. And they shot holes in it, and they messed up the intent of the bill. And there was a subcommittee that senators referred to, and Bill Yellowtail came out with amendments to patch those holes. And there was and I'm going to digress in a little story here, but so being a young lobbyist, there were several of our young lobbyists. We, in association with getting these amendments passed, we started a state petition. The Montana Wildlife Federation was the spot to start that petition because we had affiliates in literally every town in the state. So we started that. But some of us young lobbyists had this brilliant idea that we were going to enlist some of our more attractive young co-eds from the University of Montana and haul them to Butte. And we did. And we put them in the St. Patty's Day Parade. And they chanted all the way down the street, if you want to go fishing, sign the petition. And it was a stampede. And they got to this hearing that we talked about where not only did Medicine River Canoe Club have their paddles up there beating on the floors, but there was fishing rods and fishing nets and people in hats, and it was you could have never made this stuff up. I mean, you couldn't get by with that today if you tried. But part of that, we rolled that scroll with over 12,000 signatures out across the floor of that hearing room, almost hit Jack Galt in the head, but rolled that out. Most of those had come from Butte, Montana, but so it was a extremely great, good time working with great people, and the bill, the end result, was a tremendous outcome for all the citizens of the state. And these guys all did a lot more than I ever did. I was just kind of a grunt, but I sure had a good time doing it.
Judge Kruger, would you come down and or provide from that perspective, your perspective, because you were involved as well?
Thank you. In 1985, I was a freshman legislator from Butte, and obviously was very familiar with Tom Finney, Shonans, and Jerry Manley. I happened to, I was intimately involved with the passage of the original House bill, and I had the pleasure of serving on the conference committee that eventually resolved the differences. And I think how that bill actually came about, I'm not sure it could happen today. It came about because Republicans and Democrats didn't talk. Nowadays, we find that people don't talk. They don't try to, they become so partisan. And it was really reflective of this bill, Ron Waterman's work on behalf of stockmen, livestock, together with the recreationalists. I think that's how they were able to accomplish the passage of this bill. And I would hope that we continue to see that type of thing in the future, because this has clearly established a foundation for recreation and water rights in our state. I've also had the opportunity to sit on the Supreme Court on 2 occasions that, in terms of the interpretation of this bill, I've had the opportunity to serve on the Kennedy case that decided access from bridges and had the opportunity to revisit this legislation. The Supreme Court looked and made determinations on access to the waters. I also had the pleasure to serve on the state of Montana versus PP&L, where we did find that PP&L had did owe the state of Montana some money for taxation for the riverbed. That bill was later, or that case was later overturned by the United States Supreme Court. And it's interesting that the United States Supreme Court, as you're aware, most of the Supreme Court justices are from the East. I think their definition of navigation is that they look at the Hudson River in New York and say, that's what navigation. They overturned the PP&L case based on, they had the portage on the Missouri, so they said that wasn't. But I think it's really commendable how the citizens of the state of Montana and the recreational work together to accomplish this bill. Thank you.
Well, before the break, I get to sort of give the last word, and that's always nice. My memory is a couple of things. First of all, I had the good fortune of having lobbied the legislature. By then, I think the 85 session was probably my fourth or fifth session of lobbying that. And so at that time, when you went around trying to figure out who was going to support it, I knew who the leadership was, and I knew the importance of making sure that the leadership of the House and people who were respected were on that bill. I think we had 20 or so individuals who supported it. I wanted those co-sponsors, those first two names, to be Bob Marks and Bob Ream, because both of those were leaders on the two sides of the aisle, and I think that was important. I have two things that just to pass along. As we worked out the language of what this bill was going to look like before the session, when we finally got to a final end product, all of the groups made sort of a pact with each other. And one of those things that was most important was we agreed that we would splinter, if you will, that we would stay together and we would not accept amendments as individuals representing one client or another unless the amendments were acceptable to the whole coalition. And what that did was it kept that coalition together during that entire session, because individuals, the Jack Balts and others and people on the other side, could come to individuals and say, well, I'll give you this if you can support it one way or another. And we would circle back and we would have meetings as to where those proposals were, but we didn't agree to any amendments unless it was agreeable to all of us. It had to be okay with landowners, it had to be okay with recreationalists. We identified with each other and we trusted each other. We had the trust of each other and the support of each other to do that. The other thing that is a sort of an aside, but nevertheless it was an important part of trying to hold together the landowners, was at that time I realized that my clients had suffered what they thought was an extreme loss one way or another with respect to the stream access litigation. And so the question was, what can we give them? What can we do? One of the things, if you go around and you see yellow or orange, bright orange signposts and things along those lines, my idea was going to individuals. I asked landowners, how can we solve a problem that you have and we can put that together? We put together a revision of the trespass laws to make it easier for landowners to mark their land so that the public would know that the land was closed if it was closed. And that married with the stream access law. So they got something out of this. They got something to make their lives practical on a day-by-day basis. And I think that helped with respect to the landowners. And everybody is talking about, it is a shame that we did not videotape that one evening hearing at the old Supreme Court chambers, because it could not be duplicated today. But it was a surprisingly interesting outcome. So that's what I have. Yes. Oh, yeah. Tom has just a real quick vignette. We have 4 or 5 minutes.
I'm Tom Beauty again from Butte, and I appreciate Ron Waterman. About a month ago, I got a letter from him requesting that, asking me if I would be interested on being on this committee, Symposium for the Stream Access, and I was really elated to, I was honored to, when Ron asked me to be on this committee, and he asked me if I would write up a 3 or 4 page letter to how the Stream Access started and how we did it. So I started writing a letter, and I thought, geez, I can't write 4 or 5 pages. So what I did, I went through how we started the Stream Access with Jerry Manley, Dale Josevich, who's up here, and started, first of all, how we started the Stream Access. It's amazing that we hired Jim Getz, and I've dealt with a lot of attorneys through the years with the Anaconda Company on workers' comp cases and litigation and everything else, and I've never met an attorney like Jim Getz. I can tell you, he's a remarkable guy. He's a sincere guy, and he's very sharp what he did. It just amazed me that we got that type of attorney. We're lucky, very lucky as sportsmen to have gotten Jim as our attorney, and I think landowners feel the same way. They were happy. But anyway, just let me go through a few things. When things were happening in the 70s in Montana, a lot of the landowners were starting to cause problems on the river. Curran was harassing sportsmen floating down the river. What I understand, he ran over a gal's and a guy's rubber raft up there on Dearborn. She called me when we just filed the case on the district court and asked me if we would help out to take care of her raft. He ruined it. And I said, get an attorney, and she did, and they got a new boat and everything else, and I was happy about that. Anyway, first of all, when Jerry Manley and Dale Josevich, I can say that I knew Jerry and Dale for years, and I think Jerry and Dale used to drink every afternoon after work, go down to the plaza and bullshit, and they cornered me. I think they cornered me. They said, well, here's a sucker. We'll get Tom to really help us what we're going to do. I said, yeah, thanks a lot. And anyway, first of all, we talked about what was happening on the rivers, what we're going to do. We're going to have to do something. Al Lubeck, who couldn't make it today, he was going to come down, was a lobbyist. He's a good friend of mine. Al had put a bill in the 70s, legislature on navigable streams. And, of course, when he went into the meeting of I shouldn't say the cowboys, but it was all agriculture people, and they were all ready to throw Al out of the room. No way are we going to talk about a navigable stream and you're going to, put a bill through. So that got killed. Anyway, so we start talking, Jerry and I and Dale, and we talked about getting an attorney and maybe file a suit. Montana, we had to do something because we're going to lose all our rivers, and we're going to lose our rights to fish and float and everything else. So I called Urban Roth. Urban was a good friend of mine and knew him in Butte, and he's a great attorney. Called Urban, and I asked him, I said, Jerry Manley and Dale Josevich and I got an idea. We want to file a suit possibly on some of these rivers that's happening. He said, boy, Tom, I'm sorry. I just been hired by the federal government to litigate the river over at Hart on the on the Bighorn River. And he said, I'm hired by the government to do that. But he said, I would suggest that you call an attorney by the name of Jim Goetz. Jim lives in Bozeman, and he said he's a great water attorney. Give him a call and see if he'll help you. So I called Jim, and then we set up a meeting. Yeah.
Make it a little bit short because we're about just short.
Okay. So we set up a meeting and we met with Jim Getz down in Three Forks. I'll tell you another cute story. Don Bianchi, who was sitting up here, was informational director for the Fish and Game. Don told me last week, and I think he was working for Jim Flynn at the time, and as Jim was a director of Fish and Game, and Don said, well, you remember the first meeting you guys had down in Three Forks? And I said, yeah. He said, well, I brought Jim Getz down in the company car. I didn't come into your meeting because I thought I'd get in trouble. And I laughed about that. I don't know if Jim ever, but anyway, Jim Getz, when we met with him and set up everything and he decided the rivers, his fee was $35 an hour compared to 70. He said 40 today. No wonder he got so much money from it. Charged us an extra $5 that I didn't know. But anyway, things went on. We won the decision all the way through. I'm not going to go through anything more. Ron wants me to just cut it short.
Oh, we're going to take a...
But anyway, thank you very much.